Good evening, everyone. Thanks for joining us. Today is the January 16th, 2025 Town Board Workshop. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And thank you all for coming out. I know it's cold, but good to see so many people out. That's very good to see. And basically, we want to have this workshop before our town board meeting so we can have a clear understanding of what's going on. We have a couple of projects in town right now proposed that have a little controversy, and we want to make sure that the public understands what the processes are. Also, the town board can understand a better little overview of them as well, and the process as well, because the town board does not oversee these, it's the planning board. But I'm going to go just through a few comments about some of the topics that we've been hearing, some of the issues that we've been hearing, and just get a little understanding before I have the attorney go through the process and how it all falls to the planning board to go through those processes. So obviously, all these projects before the East Fishkill Planning Board, they go through the same process of New York State secret review and our review as well. We have a strict firewall, this town board, between the planning and zoning boards. This is reason for that is to make sure that this town board does not have any influence over the planning and zoning boards. Those are independent boards. Ethically, we do not comment, we do not attend, we do not review any planning board, zoning board meetings and their processes. That's why they have their attorney at their meetings, they have all their town consultants at the meetings, all separate from the town board. Comments have been made in the public that the planning board and zoning board members should be elected, not appointed. Well, that's not up to us. That's up to New York State. New York State legislature sets those laws. So if anybody would like to change that, that would be great for us, that we don't have to appoint them, but you need to contact your state representatives for that. So all property owners have rights. Property owners have rights as homeowners, and developers, commercial, industrial owners have property rights as well. These rights are protected by federal and New York State laws. Town governments like us, we are considered extensions of state government in the sense that the state grants us their legal powers. However, local governments also act as independent in our different jurisdictions to play the active role in the intergovernmental process between state laws, federal laws, and what we have to make sure that they're implemented. So, that being said, we have to make sure that all New York State laws and processes are being adhered to. That's why there's a long process that all these projects go through. We make sure that they're diligently enforced, and we make sure that no one's rights are being trampled upon. Your rights and the property owner's rights as well, whoever they are that put projects forward. The town also, we have no say as to what companies come here and want to build on these properties. Just because we do not like a company, I'll use Amazon for example. I particularly don't care for Amazon, but I can't arbitrarily say we're not going to give approval to them because we don't like them. We have to make sure we follow the law and that we are not bending the law. Okay, so because what we also hear in the public is that the town doesn't want to get sued. Well, that's not entirely true, but it is one of our main objectives, this town board, to make sure that the taxpayers don't fall into any litigation whatsoever. Litigation from lawsuits is very, very costly. Just last year, we settled an old lawsuit with our police department. It was over 10 years old. The town board was able to get our insurance carrier to put forward the full amount of our policy, which was $11 million, and it was a $20+ million lawsuit. If that were to happen, what happens is our policy would pay, and then whatever's over that amount, the town has to pay. And who's that? Us. us taxpayers. And by New York state law, we can only bond a lawsuit up to 5 years. So if there was a $20 million settlement and insurance paid 11 and we have to come up with $9 million, we have to pay $9 million over 5 years. What does that mean? That means that we're going to have to increase taxes 25 to 30% for everybody just to pay that lawsuit. So to say that the town is afraid of lawsuits, not that we're afraid, but we have to be very cognizant. We are dealing with all taxpayer monies. We have to make sure that we diligently spend those monies and make sure that planning boards, zoning boards, town boards stay within the law to make sure that we don't enter into any litigation. So, the town board, we did a moratorium last year, so people may not know that. Last year, we implemented a moratorium. We're in the midst of a master plan, so we wanted to make sure that certain projects that are coming forward to the town may be slowed down a little bit because there's a lot of projects coming in and we have a master plan being completed. We want to make sure that these projects coming meet what the public wants. It meets the ideas of the master plan. So while we're in the middle of this master plan, we said let's put a little time out, take this moratorium, and see how we could slow them down. Certain projects, though, there's 2 projects we're discussing tonight. One is Woodland Estates, which is all those condos that are presented or apartments right across from Town Hall, and the Treetops project. It's difficult. Some of these projects have vested property rights. The town attorney will go into that a little bit more in more detail, what that means. But what it basically means is that once we put a moratorium in place, if we are ever challenged, we have to make sure that we win that challenge, right? We don't want to do something that's against the property owner's rights, and really they have vested rights, so they'll sue us and win. So when we enter into these sort of moratoriums, or even say, let's go further to decisions from the planning board, and the planning board has the right to review all these projects, which they do. We'll go through the whole process, and then at that time they have to make a decision at the end, or they're going to deny it or approve it. Now let's go to denial. If they say we want to deny the project, they want to make sure that these projects are being denied for the right reasons. All the reasons that the public came forward and said, these are the reasons we don't want these projects in the town. Traffic, a school, affect the schools, what have you, okay? And there's so many more, environmental, everything. We have a scoping document which goes through that whole thing. The attorney will review, show you what that means as well. But say we deny the project, we want to make sure that the planning board, when they make that decision, they're on sound footing. Otherwise, what happens? We get into a lawsuit. Then the developer will sue saying that, well, this wasn't properly done, or they arbitrarily denied the project because of this. We have to show, beyond a shadow of a doubt, why we did that and what are the reasons that the developer isn't mitigating the issues that the public has said adequately. That's a good reason to deny a project, but we have to prove that, right? Just in case we ever go to court. And if it does go to court, it goes to a judge. And the judge will decide whether or not we did it right or we arbitrarily denied something. Then they'll make the decision to say whether or not the project's going to go forward and how big the project's going to be and how many units the project is. And now it's out of the town's hands. Now the planning board doesn't have a say anymore. Now the court decides. And I don't think I would rather have the planning board fight to the scope of a project than some judge, and based upon what happens in court. Another topic I like to mention that has been come up in the public is tax phase-in agreements, which is tax pilots. So the Dutchess County IDA is the authoritative board that decides if they're going to grant a tax pilot or a tax phase-in agreement to an applicant. I have no idea at this point whether or not any of these projects are going to go forward and seek a tax pilot or a tax phase-in agreement or not. That happens a little bit later in the process. But what happens is, the IDA looks and sees what are the benefits to the community, the town, the county, the whole community as a whole. And they say, okay, based upon what the project is going to do, give jobs, spend money in different community development, infrastructure, water, sewer, roads, whatever that is, they decide that, okay, based upon that, they will grant a pilot to this company. And that being said, they set out a schedule of payments over 10 or 15 years, and that's what they pay. So the public is a little misconstrued on what that means. They think that they don't pay any taxes. Well, they pay a tremendous amount of taxes. One example is, the only actually example I have right now, because it just started, is the pilot for Amazon. Amazon currently started their pilot last year, because they opened their doors the previous year. So here it is, they in 2021, before they started the project, what was there? Was vacant land. It was pretty dismal. I think we all can agree to that. At that point, they were paying a combined tax bill of $152,000 a year. $115,000 to the school, $15,000 to the county, $16,000 to the town, $4,000 to the fire, and $1,000 for our library. Okay? 2024, the first year of their pilot, which is the year that they get the biggest tax break or incentive of that. Every year after that, it goes up and up and up. They pay $316,000 worth of taxes. $213,000 to the school, $23,000 to the county, $28,000 to the town, $39,000 to the library, $11,000 to the $39,000 to fire, $11,000 to the library. Why is the library and fire so much more than before? Because special districts like fire and library are not included in pilots. They have to pay full freight to those, and also water and sewer districts. But from $115,000 before it was developed to $213,000 to the school district in its first year, the IDA says that's a benefit for the community. Why? Because the school district is our biggest tax bill. It's 77% of our taxes that we pay go to the school taxes, right? So they say that an industrial use like this is a benefit to the community because it does not produce one kid that goes to school. All those dollars are going directly to the school district. It costs us a little over $18,000 per student per year to teach them in our public schools. So that's a big cost. How do we offset those costs? By having companies like this come in and pay. So I just wanted to bring that up because there was a lot of questions about pilots. What are the benefits of them? And I just want to say that being a concerned citizen like you all, being here is so very important, okay? And there's many comments on social media that the town board doesn't put out information, or we're trying to hide something. That is very far from the truth. But we need people to be active participants in our community. This is a participation sport. We put the information on GovDelivery, on our Facebook pages, on our website. But you have to go get the information. We can't spoon feed the information to you. There's 32,000 residents in this town. So I'm happy to see a crowd like this come because I know you care. We care too. We live here too. We pay taxes here. So we just want to make sure that everybody understands that we're here for you. Please don't listen to social media. Call us. Sometimes I have residents come in my office, I'm sorry to bother you. Why? I work for you. Okay? You put me here, all the board members here. We're all residents. We care about this town. We want what's best for the town just like you do. So I want the attorney now to go into the process of what happens during these applications. Maybe give a little history of each one if you could.
Sure, Supervisor, members of the board, ladies and gentlemen. When I first moved to the town in 1980, Twin Creeks, i.e. Woodland Estates, was very controversial. I never thought that 40-some-odd years later, I'd be sitting in a room talking about that same project. But back then, the only way we were able to get information about what was going on, there was no cable TV with the town board meetings, there was no social media, etc. There was a little Hopewell Junction newspaper called The Lookout. And it all came back to me in a flash when I was going through the file that the town clerk assembled for Woodland Estates, and I'll talk about that first. It's about yay big, the file of paper, but there is a full article from the Lookout front page about this site and this project. So it brought back a lot of memories, and also, as I said, I didn't think I'd be here 40 years later talking about it. But the genesis of the zoning in this property is an outcome of a 1978 lawsuit referred to as Berenson versus the town of Newcastle in Westchester County. And Mitch Berenson was a prominent developer in Westchester of apartments and multiple family housing. And he went to Newcastle and said, I want to build multiple family housing. He asked for a rezoning. They wouldn't rezone the property. And so then his lawyer, Stuart Schamberg, who became a very prominent land use attorney in the state because of this case, sued them. And he said, your zoning, since it only allows single family homes on 1 acre, 2 acre sites, et cetera, is exclusionary, it's unconstitutional. And the court agreed. And they voided the zoning ordinance of the town of Newcastle. And that case, even though it's from 1978, went to the New York State Court of Appeals, the highest court, and as recently as 18 months ago, the Court of Appeals acknowledged that that's still a valid law in New York, the law interpretation of the Constitution and the laws of the state. And what does that mean for us? That means if our zoning ordinance is challenged and we don't have any inclusionary zoning, various types of housing, because, you know, we have people who don't want to own a home, but they prefer an apartment, they prefer a condo, all different housing types, then it's presumed to be exclusionary, and the court can void the town zoning ordinance. The developer who's then suing is going to get what he or she wants, where he or she wants it, irregardless of the zoning, and then the town has a limited time to go through a whole zoning process and rezone things. So the article in the Lookout referred to Berenson, and if you go through the records of the PRE zone, which pertains to Woodland Estates, you'll see many references to the town board of 1980, 81, 82, 83. Their intent was to address that issue because it did become a very big issue in zoning and planning circles in New York State. So in 1980, for this specific reason, the town board went through a process to create what was called a planned residential district. And the intent of that was to allow development of up to 6 units per acre on a parcel, on a gross parcel count. And one of the whereas clauses that the town board has there, citing their obligation to provide a variety of housing types. It also, at the time, complied with the master plan that the town had in place. Now, over the years, things have changed in the law, which I'll address some of it, but at that time, wetlands were somewhat just starting to come into vogue to be regulated and reviewed. The importance of wetlands was finally being accepted on a generalized basis. And all of the other developmental issues that today we commonly address, back then weren't as thoroughly addressed. So the property owner at the time went into the planning board and sought approval of a PRD project, Planned Residential Development. And what they came out of that whole process was an approved plan, and there's 2 parts to a development. There's a subdivision, which probably everyone who lives in a single-family home and has been developed since, say, 1975, your home is a lot on a filed map. That's a subdivision map. It's a division of the property. And there's a process that was gone through in order to cut, say, a 100-acre farm into 80 or 90 lots. So this developer went in and got approval for the entire site plan of the entire site for quote-unquote 468 units, but an actual subdivision for 220 separate lots. Now, the concept then was they were going to be townhouses, and townhouses are on tiny lots, but they adjoin each other and they're owned. So that was then taken from the town approval, and was filed with the Dutchess County Clerk, which actually divides the property and engenders 200 and some odd tax bills. So that's where the status is since the early 1980s. So then, as time went on, in 1988, the town boards were faced with two issues. Mulford Farm, I don't know if anyone has been around that remembers that, on Fishkill Road, and also the Cannon property across the street from the town hall. Mulford Farm was proposed to be a soil mine, and it was 200 and some odd acres, and they were going to dig and have a soil mine right in the middle of town. It was very controversial at the time. So the town board in 1988 went back to the drawing board, and they said, let's do something that's going to prevent a soil mine in the middle of town, and let's do something that's going to modify the PRD, because, you know, maybe it was too much too soon. And they created what's still on our books as a conservation residential district. And that allows only 4 units per acre. And hence, that's how Hopewell Glen and Four Corners, thank you, were developed. And the property across the street was eligible for that, but many of you may remember in about 2007 or 8, the town actually acquired the property across the street for utilization for some town well fields, and also the company was going bankrupt, and it was a good deal at the time. So in 1988, CRD became the multiple family zoning of the town, and they specifically acknowledged in that law in 1988, you know, PRD is repealed except for the parcel that's already been zoned PRD and has relied on it, which is Woodland Estates. So that's 1988. At the same time, and I'm trying to do this very simply, I'd be happy to meet with you at different times, but at the same time, obviously, when you have multiple family development, you need sewers. And the town was looking, there were some sewer issues in the Hopewell Hamlet area, and also the Unity Plaza wanted to come in and be built. And when that first opened, they actually had a tank truck for their septic because the sewer wasn't ready. And the town board in the late 90s developed a concept for the Hopewell Hamlet Sewer District, which is the sewer plant that now exists across the street. And that was the concept to support that sewer plant, to get it up and running, was that all of these projects would feed into it and support it. Woodland Estates, Hopewell Glen, Unity Plaza. And it took 12 years to get that off the ground. So I think that's why Woodland Estates was not developed during that time, because they had to wait to see what was going to happen with the sewage disposal. So that came on board. They then came back in about 2006, 2007 to the planning board to talk about revitalizing the 220 approved lots, but they came once or twice, discussed it, and never came back. And then fast forward, we come that last year, they came and mentioned they're ready to come in to pursue not only the 220, but the full 468 units. So I said to the supervisor the other day, the legal facts and the issues presented here are perfect for law school. If I was a professor in law school, it brings together so many issues. He indicated about due process and property rights. We all have that. The homeowners who join it, the residents of the town, everybody has due process rights. What due process is that if you're an owner of property, you can come in, make an application, and you'll be treated fairly, equally. You'll be given the right to be heard, and that's extended to the right to be heard of everyone else in the community who might be affected by it. So that's due process. We have a second issue, property rights. Everybody who owns a piece of property is entitled to utilize the property in accordance with law, whatever law allows. So that is your property rights. So Woodland Estates property is currently zoned PRD because the town board in '88 left that zoning in place. They have a filed map. When you file a map, it creates the lots, and that's in perpetuity. Okay, the only one who can dissolve those boundary lines is the property owner, and obviously I don't think they'll do that. They have an approval of a site plan, conceptual plan for the whole site. There's an issue of pre-existing rights. There's been a lot of laws that have changed over the years, and when you act under a law and fulfill all your obligations, and then the town or the state or anyone changes it, you have pre-existing right. You have the right to continue as long as you were in compliance with the law when you did that. The Berenson issue came into play, and also all these years, they've been paying a sewer payment for 220 some odd units for the Hopewell Hamlet Sewer District, as I explained to you. So all those create legal issues that are unique to this site. Normally, people come in, you have a vacant piece of land. The only issue you have is, what should be there under the current zoning. Here we have many other issues. And while I'd like to think I'm, 43 years doing this, that I know everything about municipal law, I don't. So what I did was, early on when this application came in with the consent of the town board, we sent the entire file, all the documents, to the law firm of Sy, Podgett, Rizel in New York City, a preeminent environmental municipal law firm. They reviewed it, and they offered comments to us about legal rights and due process, et cetera. And the outcome was, what we should do first is let's go through the CEQA process. What is CEQA? You're going to hear it a lot if you follow this project, and also Treetops. You'll hear it a lot. What CEQA is, it's the State Environmental Quality Review Act. And the state in the late 70s adopted a law that says before any land use or any action of a town can be taken, they have to go through a CEQA process. There are different types of CEQA process depending upon the level of the intensity of the project. Both of these projects are the highest level, so they get the most detailed review. So let's just run, and I don't want to diminish Treetops, but that's vacant land. It has pure issues of what the zoning allow, how is it laid out, but the study that will follow is the same for both projects. And I think it's important for everyone to understand everyone's going to be heard, all the issues are going to be addressed, listened to, analyzed, and as the supervisor indicated, at the conclusion of the process, which could be a year and a half, 2 years from now, when the planning board looks at the conclusion of the CEQA process, that determination at that time is what's going to set the path of the project one way or the other. So let's just go through quickly. So Woodland is more advanced with the planning board, but it's still in a very infancy stage. So any applicant, any property owner has the right to file an application with the town. It then goes to the planning board. The planning board normally, sometimes even before it's go to the planning board, they ask to come in and meet with the professional staff of the town. And what that is just to give or take quick comments, technical things, maybe identify some issues, et cetera. Then from there, it goes to the planning board for 1, 2, or 3 discussions. And all discussion is they tell, this is our concept, and members of the board may make a comment or 2, whatever it might be. So then, after 1 or 2 discussions, the planning board has to begin the CEQA process. And how that is done is the planning board adopts a resolution that says, we believe that we are going to be the most significant approval agency of the project or disapproval, and as such, we should be the lead agency under CEQA. The role of the lead agent is to marshal the process, to include all the parties, gather all the information, assemble everything, so that they become lead agency. When they do that, that resolution is sent out to other parties. So let me explain that. For every project, we have to identify who else would have to give approval for this project as proposed to go forward. In the case of both Woodland Estates and Treetops, it would be referred to New York State Department of Transportation for any impacts on the state roads. It would be referred to the New York State Department of Environmental Conservation for the review and comment with respect to any state wetlands on the site. It would be referred to the United States Army Corps of Engineers, who have jurisdiction over any federal wetlands. It would be referred to FEMA for any floodplain issues that may exist on the property, and the list goes on and on. But then there's another category of parties who get notice, and they are groups that are identified as perhaps being interested in the project. They don't play any role in approving or disapproving it, but they do have a significant interest in it. The one on the top of that list is, of course, the Wappinger School District in this case, but whatever school district the process is in. So all of these groups get notice. Within 30 days, they can object to the planning board being lead agent. They can say, we think our approval is more significant than theirs, or whatever. In this case, no one objected. All of the agencies normally send a letter initially saying we have no objection, and they give maybe some preliminary comments. The one comes to mind quickly, New York State DEC always writes back and says, we think it may be needing a wetlands permit or stream permit, whatever it might be, just fast and dirty. So that comes back, and the planning board then declares themselves as lead agent. They then go through the next step, which is the step that's just been completed over the last 2 months, and they go through a scoping session. What a scoping session is, it's a creation of I call it like an index, a list of chapters that have to be studied and addressed by a project. So the planning board will, on January 21st, I believe, the next meeting, take up a scoping document to say, okay, we think we've heard comments from the public to identify issues. We think this list is, at this time, complete, so we adopt this as the scope. And what happens then is that document is given to the developer. They have to go off, and they can be gone away for 3 months, or I've seen some go 2 years. They go away, and they have to get professionals and to gather information and to put together enough information for each chapter to address the subject. So what would they do? They would have to have, obviously, a land survey done. They would have to have New York State come down and agree that the wetlands that have been delineated on the property, that the state agrees they are the wetlands. They would have perhaps hydrologists and geologists come in for various issues. They may need to have a habitat expert come in because they may be the bats habitat, turtles, or any other wildlife. They'll have to have a traffic engineer do some studies to formulate the traffic impacts and how they propose to mitigate it. And that will be the next process that goes on. And ultimately, what will happen then, at the end of that process, the applicant's going to come back, usually in this case it'd be 2 volumes, of their proposed draft environmental impact study. And that will be submitted to the town. Even though they had as much time as they needed, the town only gets 30 days to review it under the rules. So the town gets it, and the town, it's just not the people sitting in this room that look at it. We have our traffic engineers are here. They'll go over the traffic part. Our town engineer will coordinate it. We have hydrologists. We have wetlands expert. We have all consultants that we use at the applicant's expense to review what they've put together. And then all of those professionals do comments, which are then submitted back to the planning board. The planning board then looks at the comments, looks at the draft environmental impact statement, and decides, these comments you have to address, and they'll reject the DEIS. This is the normal, usual process. It goes back to the applicant, who then has to update what they've done, address the comments of the professionals, and then they resubmit it to the planning board. At that point, if the planning board thinks it's sufficient enough to allow the public to formulate enough or have enough information to formulate comments, the planning board then will accept it as complete. But that doesn't mean that they're agreeing with it. It just means that they feel there's sufficient information about all the subjects for the public to be able to rationally, reasonably, intelligently address them. They then schedule a public hearing. That public hearing is both on the environmental process and all the impacts and on the site plan that may be before the board at that time. We should understand that the applicant in this process, as they do all their studies, they can modify and change their proposal. They could change the layout to move it away from a wetland they identify. They could reduce it because they think the traffic impacts are too expensive to mitigate. There's, just off the top of my head, 2 things that they might do to address it. So at the public hearing then that's held, everybody has the right to speak. Every resident of the town of East Fishkill, you address the concerns. You can perhaps raise issues that were not thought of at the beginning because they've only arisen during this process, and all of that's put into the record. Then the planning board will adjourn the site plan public hearing and would close the secret public hearing and say to the applicant, okay, you go take the transcript of this hearing and address all the comments. And they have to go through every comment that's made by every resident, anyone who speaks, and respond to it. Now, a lot of times they just say, Mr. Smith's comment is addressed by page 7, paragraph 2, or whatever. But other times, there's new information that they have to generate. That's put together and comes back to the planning board in a final environmental impact statement. And the planning board at that time has the right to hold an additional public hearing to get further comments on it. And it's only after all of this process that we get to the point of decision-making. And there's 2 actions then the planning board at the end of this process has to take. One is it has to consider a finding statement. And what that means is they go through SEQA and they say, we find that these are the issues, the wetlands. Then they have to, so let's just take wetlands. So they may find that, and I haven't looked at the plan in detail, I'm just summary. So with the wetlands, they may find that all of the disturbance of properties outside the wetlands and the boundaries, the wetlands, no runoff goes into the wetlands, whatever it might be. So what's shown on the plan for wetlands may be found acceptable. They then may go to traffic, and they might say, well, now traffic is complex. We all drive and get stuck in traffic, but the way DOT, and I don't want to step on Brendan's domain, but they classify every intersection has a classification, and then there's an analysis done based on assumptions of how much traffic will be generated at what time. So that will be all there. And the planning board may agree or disagree with that. And they can rely on our experts if they disagree and require additional things or reject the mitigation. So it's only after that process is done and a finding statement is adopted do we know where we can go with the project. If the finding statement finds that there are significant unmitigated impacts, then the planning board cannot approve the project because impacts have to be reasonably mitigated. If they find that the mitigation as proposed is satisfactory, then they go into the approval of the site plan and things like that. So I think what I'm just trying to get across is we're at the very beginning. It's a very important of concern to everybody. Treetops would be, if you're here for treetops, it will be subject to the same process. Some of the things just came to mind. There's a visual impact chapter. They have to show with computers, they can show this is what it might look like from various points, scenic views. So there's a lot of material that has to be developed before we'll be anywhere near where we're going to be. And at this time, there's been a lot of comments filed with the planning board already, and the applicant has to address them. The town supervisor, on behalf of the town board, because they can make comments that way, so that's in the record. And the school district has written and sent the letter. So with all of that said, I probably talk too much, but that is the process. And I think the biggest takeaway, hopefully, will be that everybody wants to hear, listen. We have to do it in a rational, reasonable way, respecting everybody's rights, and follow the laws and the rules. And hopefully we'll be successful, whatever that is. Okay?
Thank you. Thank you to the town attorney. Does the engineer have any comments to add to the attorney before we go into some questions?
Now, let's go into questions, so
Okay.
that might come up.
That's a good idea. So as I mentioned, as you saw, we do have a town board meeting at 6 o'clock. So I said we would take questions if time permits. It does. If we don't get to all the questions and we have more concerns, we'll gladly have another meeting to answer questions and do whatever. But if you'd like to come up to the podium, ask your questions, and we can address them.
No questions.
Hello, everyone. Tony Taylor, thanks so much for this meeting. So just a couple questions to process. Thank you so much for the overview. And I love your little flow chart. It would be lovely if that was easily findable on the town's website.
The last page of the handout is that flow chart, but not in chart form
Yeah, the chart form would be helpful.
Okay,
because then
great. I'll put that
saves
up.
the community from having to put it in
Sure.
chart form to better understand the process flow. So my question would be, I love I appreciate the point that this is early in this treetop process. I think that does make sense. And all the levels of comment, while clunky and the communication's a little clunky, that's fine. But I'm curious about the glaring lack of, is there like a cash flow? It's like where is the financing for these projects coming from? Is that tracked? Is that audited? Are we aware? I mean, is there some financial audit? So if somebody comes to you and says, second question, who provides oversight to the planning board? Interesting question. But I'm curious about the cash flow and the audit process. So if a developer comes to the town with, sure, I want to go build this project here, and so do you have the financing to do it? We all had to qualify for mortgages, right? So is there any financial qualification of that?
No.
Oh,
New York State doesn't require the developer to, so hence, people who own properties, some people come and get approvals, and then they go market the approvals. We have no control over that. The only thing they need when they come into us is they have to pay whatever the application fee is. They have to put up an escrow to pay the consultants that we spoke of, and they have to either own the property or have consent to the property owner to make the application.
But that's a very good point, because sometimes these projects start, they never get completed. Case in point, Route 52, the old dome. Disaster, nightmare. It looked like hell for many years. That's why we were thankful the town board moved forward our economic development plans and tried to get that to market, and we were successful at it. But what happens? Unfortunately, New York State don't care. They don't have any laws that say that they have to complete a project. So we're subject to those laws.
So what we do when it can be done is that, first of all, any improvement that has to be made that's going to be turned over to the public is eligible to be bonded. So before they can start work, they have to post a bond that would ensure that the public, a water main or intersect, whatever roads, something like that, would have to be bonded to ensure that that would get done. As far as on projects that are more than one building, the dome was one building, so you can't, but on projects that can be, the planning board then requires a phasing plan that before you can go on to section 2, you have to completely finish section 1. And that's the protection, if you will, of having somebody just start on the whole site and leave it.
And to the planning board, there's no oversight. Is there any oversight functionality of the planning board, either at the town level or at the county and state level? Who oversees the planning board?
The planning board...
Balances the power, because it sounds like the planning board has a lot of power. Who balances that?
Okay, well, first of all, the planning board has to work within the law, and the law that they're working with is the zoning law, and the zoning law is adopted by the town board. Then the planning board works within their defined role under state law and town law of reviewing projects, site plans, subdivisions, based on what's in the zoning ordinance and the state laws. The planning board, as the supervisor alluded to, is independent in that once a member is appointed, they're appointed to a 4-year term and may only be removed for cause. Okay, so that, and the thought process...
I'm still not hearing oversight.
oversight would be if there was grounds for cause, the town board could take steps to remove that
No,
member.
she means who oversees the planning board? Nobody. They're an independent board.
yeah.
They have to follow the rules and regulations of the state of New York, just like we do.
Okay, all right, very good, thank you.
Okay.
Any other question, please?
Good evening.
How are you, sir?
Very good. How about yourself?
Good, thanks.
Good. Thanks for a good presentation, Tom, and you also. Would you be able to show on a map exactly where this piece of property is, like parcel access? Or I looked into it a little bit on parcel access, but I wanted to make certain before I remarked if I had.
Which
Which one?
project?
Is it for the Woodlands, I guess it is?
Yeah, right across the street?
Yeah. Which is,
Let's see if you
which is the one with the 400 and some odd units?
Yes, that's Woodland Estates across the street.
And is that tax map ending in, or 406-146?
No, I couldn't tell
We
you.
we would have to get back to you on that. I don't have.
Multiple.
It's multiple.
It's multiple, well,
parcels.
it's 200 and some odd tax lots, because there's all the little lots. so.
The parcel I just referenced is like 79 acres. Does that sound?
There's like 12 different parcels.
Yeah, that looks like where I was talking about. Where all that multi-unit dwelling is on there, is that future? That's not existing yet?
No, what they did is they commenced construction, there's some foundations.
Okay.
And part of a water system
Water
that was
tank, yeah.
that was developed.
And those lots have already been created.
So I was correcting, I believe, on the larger adjacent parcel. Could you click on the, yes, that one. Okay, so I believe that 406-146? Yes. Okay. So looking at that, is it accurate information that they have been paying $62,700 in sewer tax per year?
I don't have that information.
How much did you say?
Available, but
They do have 240 benefit units and have been paying into the sewer district for
Several years.
almost 20 years now, yeah.
Okay. So, I mean, and not utilizing anything.
No,
Utilizing
Right.
anything.
Okay.
we were always,
another predicament.
But they have certain rights to the sewer because of this.
They're in the district.
I'm sorry?
They're in the district.
They're in
The district was
Yeah, I
formed.
get that. So here's where I have a little bit of an issue, and I'm sure most everybody in the room does, is the impact it'll have on our school and, expansion. We're going to have to expand our schools. And in the Wappinger School District, they've been paying $8,000 a year, significantly different than what...
Well, is raw land, right? They don't pay upon what could be there because they don't have final approval or nothing is built yet. But the school is an interested party. The school did, and I just reviewed it actually the other day, the letter that came from the school district on that project, Woodlands Estates, and they did identify that they will need significant economic contributions to the school district if that is to move forward, because whatever then when the scoping's done and then they do the studies and whatever formula they formulate to say X amount of children will be going to school from there, they have to mitigate that. How? That's up to,
I don't know if they'll be going to Grayhead or they'll be going to Van Wake.
well, there's,
We have an existing problem, and DOT would be involved in it at Van Wake.
yeah, there's school laws that they have to adhere to, the school district, meaning that students could go to whatever school, but they'll identify needs that need to be mitigated at these schools in town that they'll have to, that's up to the applicant's problem to fix that. If they can't, then they won't get approval.
Okay, all right, that was the point I wanted to make. Thank you.
You have the info. Hi, how are you?
Good, how are you?
Adam Tinter of Tamarack Drive. So the question that I have here is about the treetops. project in that lime kiln zone area where, according to a 2019 study conducted by the town by Behan Planning and Associates, studying all the industrial zones in the area, recommended that that area be changed, the zoning be not conducive to industrial use. And yet here we are being said that the industrial, prior to review of industrial areas, did not recommend a change. But in this 2019 study, it does not state that. And there are several parts of it. It's a 54-page study. It states it on page 30, again on page 38, where it highlights the bullet points of that zoning. So the concern here is there's nothing wrong with the application for treetops. They're doing what they're supposed to be doing, right? The land is zoned in that way right now, and they have every right as purchasers of that property to move forward with whatever project they're looking for. But the question is, with this study being on hand, why that wasn't enacted or why nothing was changed at this point in time, and now we are sitting here as a community faced with this project, talking about it and figuring out how to mitigate it when it seems like prior to their ownership would have been a town. Now, I don't know the availability or the legal methods which the town has to go about changing zoning ordinance, so that you'd have to educate us on. However, it was recommended by a study. So, I mean, that does say that here. And I'm just curious as to where we are with that in terms of following some of those things that I'm sure we paid for.
So at the time, I can't tell you why it wasn't changed at the time, but
I'm not sure of the timing, but that site had been the subject of a prior application and approval for a crane
yeah.
story, remember that?
Yes.
And that received all town approvals, local approvals. They got into a problem with DEC because there were turtles seen on that site in 1980-something. But the DEC was requiring them to either have sheep or cows grazing on a certain part of the property to eat vegetation that's poisonous to turtles. Now, I assume that issue is still an issue. That doesn't go away, but that would be developed in the process. But I know I would have to go back and check the dates, but if that project was near approval or approved, then that recommendation would have been, a vested right. There would have been some legal issues with that, but I can go back and check that. I'm just going by my poor memory.
In the study here, it does say corporate or contractor types of use would be applicable.
Yeah.
Right.
But industrial is not. What was approved, the contractor yard, the crane school, made sense. We're not saying that didn't.
I see,
We're saying
yeah.
a 1 million square foot warehouse is exactly what this study said don't do. And it was ignored. And now we're all sitting here in this room saying, how can we possibly fight this when the zoning wasn't changed?
no, it wasn't ignored because we knew that we were way many years behind in a master plan. When you do studies like that, let me finish. When you do studies like that, these small studies, industry, commercial, whatever, those help out then when we finally going to do the master plan. Well, in 19, we says, well, when are we going to start the master plan? We have to do it soon. We're 20 years out. Right. COVID came, okay, then we said as soon as COVID was over, let's commence the master plan, which we did last year. We did identify Donovan Drive in that area that we have to take a look because although most of those parcels, all those parcels are industrial zoned, they have a lot of commercial uses. So we said then, well, let's take a look at this more in the master plan. Perhaps then we have to go when we do our ZORP, which is the zoning ordinance revision after the master plan is adopted, and that's when we actually make zoning changes. So we haven't got to that point yet.
Okay.
Is there a possibility that this could be rezoned based upon the new master plan?
Yes.
And either
There's many areas that could be.
rezoned?
Yes.
Okay.
So I just have sort of I don't know who this would be to, either Nick or to the town attorney. In terms of a legal process, if, let's say, this project were to become not fruitful for the developer to move forward, they say, you know what, it's not worth our expense and time to continue with the mitigation for environmental, traffic, whatever, right?
It's too costly, what have you.
Cost, there's not enough profit, not enough margin in it for us, we're gonna bail on this, right? Moving forward after that, they still have landowner rights, right? Those rights, according to town legal, is that those are grandfathered in.
No.
Should the town change this, well, could the town at that point in time still change the zoning? And would the existing owner still have that right, but if sold to a new owner, they would then have the new zoning law? Am I understanding that?
No, if the property is vacant, correct me
This
if I'm wrong.
property's vacant, it doesn't have prior approval of any sort for the use intended, so it can be part of a rezoning process. And I think your earlier question was, how do you rezone it? Well, the rezoning would be the town board would have to start a secret process and go through a process to rezone, and it's to that particular property or a property of that use. So it is still possible.
Would they be able to utilize the CEQA process that they're currently going through? So if the master plan comes to fruition.
Oh, with the master plan secret, yes.
No, the treetop, so they're going through the CEQA process.
Yes.
If the master plan gets completed, that CEQA process that takes, I think you said up to 2 years possibly?
Well, I think
Could that be utilized to justify?
I think the master plan will be ready far before Treetops is ready to get too far into the secret process.
But could it be utilized to rezone it?
Whatever they give, any material that we have that we can put into.
But at that time, when the town board then eventually gets to the zoning ordinance revision, where we change actual zoning, and we're going to have public hearings with the public to say, this is what we propose, and what do you think, and blah, 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 we have to rezone it something. It's going to be homes.
Right.
Then, is all the people going to be upset that there's going to be homes there? We can't zone it zero, meaning can't.
No, that's understandable.
We understand that.
No, that's
Right,
I think we're just saying it's not zoned appropriately.
right. Because we can't, we don't have to rezone it to their highest and best use, but we have to rezone it
Yeah.
for something,
And I think what
by
you're
law.
saying, like the Crane School, and that was a decent size to have there. It didn't have the implications that this
Right.
had.
Well, it didn't have the community impact or the traffic impact, both on Lime Kiln or 84.
Exactly.
Or the environmental.
Exactly, and that's why we go through these processes, and the planning board will look at that. And then when the applicant then sees what the scoping is and sees what they have to mitigate, perhaps at that time they're going to say, or the planning board can even say, well, this is too large, maybe we want it smaller, or maybe you want to do this, so then there's less traffic, and then there's less environmental impact. That's then up to the planning board, but that's why we do these processes.
Right. I guess, I'm going to speak for myself. My concern is that the board is aware of the previous study, that we are aware that should this, as part of the master plan, that this is taken into consideration for future, so that, East Fishkill as a town can preserve its integrity of the way it was studied to be seen, and not have the impacts on communities, traffic, services that are in the community, whatever it is, going forward. We realize that at this point in time, nobody is doing anything they're not supposed to be doing, that the landowner has that right. But I guess going forward, from, I think my perspective is that this is at least looked at and known that this is in place, and that we might need to reconsider this in the future. That's really what I think my major concern is at this point in time.
Sure, well, I understand. Obviously, this property and the property across the street has zoning in place for 40, 50 years now,
Yeah.
way long before us. So I had the question right away when this project came forward, said we want 468 units. Why didn't any other
Who did
town?
the study?
Behind Planning and Associates.
For who?
For the town of East Fishkill.
So if the town wanted the study, and it was done in 2019, why was it implemented? Why now did these two, gentlemen and this woman had to come forward and show you this plan if it was already in place?
We didn't have our master plan at that point.
But you
A small,
you paid somebody.
Yes, I understand.
To do this study, and then you ignored it. It's 2025, 6 years, and now you're saying, oh, why do we pay for a study that you were just not going to apply to?
we applied those smaller studies to the master plan study. I don't, if you don't like the answer, I'm sorry, but that's the
I don't
truth.
like the answer because apparently you used taxpayers' money to do the study, and then you ignored the study.
The study was not just for that property, it was for all industrial properties in the town.
Yes,
It was for all industrial properties in the town.
that's true. 100%.
but that one's for treetop.
Well, this one, that pertains to that zone.
Yeah, that one.
That's what I'm talking about.
They located all the industrial properties in town and looked at them.
Can I make a request? I know Emmanuel was able to get the town board agendas up a week prior. Planning board typically goes up the day before, and it's very difficult for some of us to adjust our schedules. So could the planning board post the agenda a week before as well?
I will request.
I would appreciate that, I think, because people try to get there, but with 24 hours notice, it
Sure,
can be
it's fine,
difficult.
yeah.
I just have a quick question.
Yes,
I'm
ma'am.
just curious, so you posted and it said like different steps in the process for treetops?
Yes.
Where are we in that process that you put up?
Treetops,
Like,
CEQA hasn't even been commenced. They're still developing their plans or whatever, the studies that they're going to submit.
But yet they're in my backyard, and I know you'll have discrepancies, but I have videos. I've seen it with my own two eyes as well, just standing there. They've cut trees, they've cleared trees,
so-
but yet, and I discussed this with you, but I'd like to
Yeah,
discuss it
so
in front of
I'd like to
everybody.
put this to rest, because
Please.
when it was brought forward to me,
Yes.
we quickly made sure that we had the applicant put a environmental monitor on that the town chose to go in there and look and see what they're doing. What
And
are they
who was
cutting?
the monitor?
The monitor is
Forestall.
Forestall, a arborist.
Is that somebody that's local?
Yes, local company. Okay, the town board
I think
picks.
you're very familiar with him, correct?
Not, the town board knows, he's an arborist in town. He sits on our CAC, so we knew in other words, we know that he's going to look out for the town's interests, okay? So we want to make sure that they're not cutting nothing they're not supposed to cut. They're only supposed to cut dead trees and brush in there with a brush hog. Further, we've also had the DEC go on site. The engineer had a review with them, walk the 100 acres.
Today, in fact.
Today, actually. And would you like to?
Yes, so the outcome of that, we're waiting for a formal report. We had Lisa Massey from the DEC and Sarah Palasic, if I'm pronouncing that right. We also had an MS4 officer, our assistant planner, and myself walk with the DEC, and the developer was there as well. So we spent about an hour walking the site, and the takeaways were the DEC was in agreement that the trees that had been cut had been dead and fallen trees.
So there hasn't only been a brush hog, there has been a saw, because...
No, but just let me finish. Dead, fallen trees. And they came out, the DEC, and they confirmed that today, as well as Forestall.
So
You
if
do
I had a
hear-
video of otherwise, what happens to this company for not following the
Well, I'd
rules?
have to see that, but there was no evidence that they cut down trees that were standing from our walkthrough, and that was the DEC was there today. The only
So is that something we
concern,
should take to the DEC? Is that who we would go to?
well, the DEC came, this is the second time the DEC has come to the site. Again, we're waiting for a formal report, but their takeaway from today was the activities that have occurred to date are okay, aside from the fact that the equipment itself is disturbing the soil. Okay, so it's not the matter that they're touching the trees, but it's that they're disturbing the soil. And they're going to report back to us, and there's going to have to be some mitigation for the disturbance of the soil itself, just from the tracks of the machines moving around.
And so
But
in
the
that
tree-
process, they
But the
wouldn't be...
trees that they're piling up and cutting and all that, the DEC took no objection to that.
But in the event that some of our neighbors who have houses like mine, which butts up against the property, who, I'm asking because I mean, I
Well, they
think
do not have
we deserve
approvals.
an answer.
They don't have approvals to
Right.
cut
So I'm
trees that
saying,
are
if we
standing.
know otherwise,
Bring that to us.
bring it to you?
Yes.
And who are you? The engineer?
Town engineer, yes.
Okay. Okay, thank you.
So at this point, what we'll do is, we have our town board meeting at 6. We can have another meeting with you. We could let the process go through and then have another meeting. I know some of you have been emailing me, calling the board. Please continue to do so. Let me know when you'd like to do another meeting, and we can have that, no problem. Because I'm sure there's going to be questions come up as the process goes along, and what happens and transfers from this project, that project. We want to make sure that all your concerns are met.
The one thing,
Okay.
Mr. Ruva,
Yes.
I'd like to add, well, as no one asked, why are they in there doing what they're doing? And they still have to do investigation for their stormwater, for wells, for septic, just survey in general. I mean, that place is so thick. It is really thick. So the DEC agreed that you got to get this cleaned up to some degree to take the next steps. So they just have to do it in a proper fashion.
So that is not inclusive of standing dead, it's fallen dead only?
Just fallen dead. Not supposed to touch a standing dead tree, just a fallen dead tree. And if you recall in Wickeby, many years ago, it was like that downburst, that wind. And if you drive, you can see all the fallen trees. I mean, there's a lot of fallen trees, so.
All right. Thank you all again for coming out. We do appreciate you coming. Thank you.
Thank you.
So we'll adjourn this workshop for the town board meeting. Do I have a motion to adjourn? So moved. Do I have a second? Second. All in favor, say aye. Aye. Opposed? Meeting adjourned. We'll take a 10-minute break.
You're going to come see me sometime?
Hey, how are you? How are you? Good to see you.